There's a few things to address, Your Honor. There is a bond violation currently right now.
Right out of the gate, we're dealing with a bond violation, which is no small matter in court. Even being just 15 minutes late can land someone back behind bars. The question now is whether the excuse offered will carry any weight with the judge.
Recognizing that it was just craziness, she had to take her there first. Lines along everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15?
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world.
Judge Fleer's tone says a lot, calm but with an edge, when he says, it's not the end of the world. That's usually code for, don't ever let this happen again. Judges may offer grace once, but rarely twice.
It's not going to happen again, though. Do you understand? Okay. All right, counsel. We good to go.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration, of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give him some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And two, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the primary caregiver of two daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
But luckily we have that going.
Well, factors often lose out of public safety concerns.
Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
No, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st. Excuse me. But yes, so they would have to move. They would have to switch schools, just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend. Is it occupational therapy? Occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had informed the court of my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, I don't want to portray myself as an expert in this at all, because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other, and so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. You know, they're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated. But all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here are, they're up there.
How high are we talking?
Okay.
The judge's shock here says it all.
The judge's reaction says it all. Shock. A 0.28 blood alcohol level is dangerously high, approaching lethal. Most people would be unconscious, not behind the wheel. This moment marks a turning point from sympathy to serious consequences. This defendant is lucky to be alive, let alone just facing trial.
You know.
Yes, Judge.
Yeah, no, and you know, I understand, and that is
You realize that most people at that level, 0.4 is death,
That's right.
right? You're at a 0.4, you're dead. A normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Well, absolutely.
Right. And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow the recommendation, because that's why we have these people. They're clinicians, they're experts in what they do. They make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. You know, I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it?
0.28.
A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
you know, and again, I know that
I understand. I'm never going to be
attributed
such a lawyer for, zealously advocating, and I appreciate it. And you have to do what you have to do. I understand. Sorry.
And there it is, the moment of reckoning. The judge isn't being harsh. He's being clinical. He's seen how leniency can lead to relapse. This isn't about punishment. It's about protection, both for the defendant and for the public.
It's too much. If it was a 0.4 or 1.4, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. We can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that when we're talking about treatment, who could speak against that? And I do understand that.
We're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that,
No, she's a 0.31 and a 0.28. Really, that needs a lot. That's why they recommended it. And I'm sorry, but I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is Your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. You know, I'll give you another 30-day setting. That's it.
Your Honor, would we give you 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for
I will give it to you, but that's it. I mean, really.
I get it.
At the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.
Yes.
Mr. Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So, correct me if I'm wrong, that he was out on bond on this case, right?
Judge, I'm not.
Yeah,
Not
we
sure about
gave him
that.
a general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back, and when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant, we revoked the bond, you ended up going back to jail, and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court, because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually putting on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
Because of the GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB.
Correct.
So you don't think there's PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated.
Things get legally murky here. A simple toll violation spirals into a DWI stop. The officer's justification may seem flimsy, but all that's required is probable cause. While the defense will lean on science, the court only needs reasonable suspicion. Two very different thresholds.
Contact with the defendant, who was the driver of the vehicle. The officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Standard sobrieties were conducted. HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was red, and the defendant considered a breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. So what's your argument?
Judge, my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes, Judge.
The stop was initially because it's a prohibited vehicle, right?
Right.
You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to the DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, .065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a .08 at the time that he was driving without any type of scientific method or any type of legal scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a .08 at the time of driving. I don't know, but that's why we have trials. to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
Right. I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial.
Yes,
I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Yes, Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 6 out of 6 HGNs, 4 out of 8 walking, turn, and 3 out of 4 one-leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you know, you may be right as far as they make, you know, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, what, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, you know, it coincides. And
Just to understand, I have to wait 30 days to set it, or I can...
no. You know, let them know now so that they can get their ducks in a row as far as subpoenas and all that, you know. And is the breath, is what discovery's in?
Yes, and it's completed, yes. You have, we're just missing station video, but everything else.
Okay, that's a big part, you know, because you're going to need that as far as breath testing and stuff. So, I mean, just stay on top of it. If you want to set it now,
Yes, Judge.
and if you want to get it a couple of weeks just to see if you can get the video,
I think
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge.